consider yourself an injured party in this matter?
I was not physically injured myself.
Hey guys,
Have you filed a claim in this matter in any way?
so I'm
Sustained.
going to, I know it's live right now,
Consider yourself to be the plaintiff in this matter.
but
Grounds.
I can't,
Sustained.
I want to be short and sweet.
Abstain.
Not relevant. Also under 90611.
And get through this real quick.
Are you aware of any plaintiff in this matter?
Oh, shut.
Grounds.
Oh my god, I think the only reason why is because,
Sustained on relevance grounds.
hey, Uncle Steve.
Ever had a conversation with the plaintiff at any time in this matter?
Objection.
Grounds.
Sustained is to the form of the question. You may rephrase it if you would like. Some more specificity.
Have you ever had any phone conversations or personal interactions with the plaintiff in this matter?
Objection.
Grounds.
Sustained is to the form of a question. You may rephrase it if you so choose with more specificity so that it's not
Yes.
vague.
Are you aware of the
Oh, I just want to
identity of the
get,
plaintiff
see if he
in this
gets
matter?
through this bullshit.
Grounds.
Not relevant.
Grounds.
It's not relevant. Sustained.
Are you aware if there is a plaintiff in this matter?
Objection relevant.
Grounds.
Objection.
Sustained
Grounds for the sustain.
on relevance grounds. Also under 90611.
With all respect, Your Honor, the jury deserves to know this information. We're withholding important information from the jury. They deserve to know this.
The jury will disregard the statement made by Mr. Brooks as not being an accurate statement of the law. Next question.
Nice. Stay mad.
So to the best of your knowledge, you're not aware of any plaintiff in this matter? Grounds.
Objection.
Sustained. Mr. Brooks, please move on to another topic under 90611. You are hereby advised that if you do not move on to a new topic, I will close the cross-examination.
With all due respect, Your Honor, this is important information the jury deserves to know.
Mr. Brooks, ask a relevant question, please.
That holds a lot of relevance, Your Honor.
Mr. Brooks, one last opportunity to ask a question. Otherwise, the court will declare the cross-examination closed under 90611.
No further questions.
Can you redirect?
No, Your Honor.
Okay, thank you, ma'am. You may step down.
Okay. So I want to get through the very
Statement calls
beginning of
next
this.
witness.
Daniel,
Here's-
Knapp.
We're going to go through the very beginning of this, and this is what got me heated today, and this is the point of this brief live stream. But I want to thank you guys for dropping in this afternoon, by the way. So thank you.
And you have simply put on here, State of Wisconsin plaintiff, that's an entity. You have to name a person, sir.
So he effectively put on his, he tried to subpoena the state of Wisconsin. And that's why she said that's an entity and not a person. So I'm not going to have you subpoena the state of Wisconsin.
The date. Well, the date we would fill in. So I'll have it shown to the state, and they can let me know their position on that.
Hey, what's up,
The
Jerry?
basis why that would not be accepted, Your Honor.
You have to have a person named, sir, so that they can come and testify. You only have an entity named.
Is it not true that under the Sixth Amendment I have the right to face my accuser?
Mr. Brooks, let me hear from the state.
Yes, Your Honor, I agree with the court's assessment. The subpoena does not state a person. The subpoena form specifically indicates that the person requesting the subpoena is to indicate the witness's name and address. Mr. Brooks has simply written the word State of Wisconsin plaintiff for the witness name. The State of Wisconsin is an entity, it's not a person. The State of Wisconsin cannot testify at these proceedings, so the subpoena should be rejected, Your Honor.
Your Honor, on the grounds that every document that was filed in this matter stated that the state of Wisconsin was the plaintiff, which would lead me to believe that the state of Wisconsin is who's bringing the claim against my client. How could they not be subpoenaed to testify if they're the plaintiff? And under the Sixth Amendment, I have the right to face my accuser.
Wrong. Dead wrong.
My accuser in this matter is the plaintiff, which is the state of Wisconsin. Attorney Opper also brought up that it didn't have an address on there. None of my subpoenas had addresses, as we went on the record, and that was stated that a lot of the paperwork that I have don't have a lot of the people's addresses on there. Those subpoenas were accepted, so I don't see the difference with this subpoena not being accepted for the reasons that Attorney Opper just stated.
Mr. Brooks, in relation to that subpoena, based upon my review for completeness, this court would note you have not named a person, you've named an entity, and the subpoena will be kept on file as part of the court record, but I'm not going to require the state of Wisconsin to testify in this case because they are an entity and you have not named a person.
Are they not, or are they not the plaintiff, Your Honor?
They are the plaintiff in this case, sir.
And why are they not able to testify, being that
So
they?
you've named an entity, not a person. People are called to the witness stand to testify. You have had an opportunity to cross-examine every single person who has been called by the state to testify in this trial. I believe that your Sixth Amendment rights have been complied with.
She's right. Sixth Amendment says that the accused shall have the right to confront the witnesses against them. It doesn't say the right to face their accuser. It says to confront the witnesses against them. Throughout this entire trial, he has been confronting the witnesses against him. The witnesses who have accused him, who are called to testify, accusing him of committing these crimes. So his Sixth Amendment has been upheld. This is a tip, and Juan Galt knows this as much as I do. This is a typical sov-sit bullshit reinterpretation of the Sixth Amendment, that it can't be the entity that accuses him. It has to be somebody flesh and blood, or a human being that can accuse him, that can be on the stand, and so he can confront him in that way or face him in that way. It's a typical bullshit sovereign citizen, and it gets me really fucking heated. It got me really fucking heated this morning to hear him say that he hasn't been able to confront his accusers when he very, very, very much so has. It's oh my God.
Not if I'm not allowed to face my accuser, Your
You
Honor.
have.
My accuser in this matter would be the state of Wisconsin. And with all
So
due
I believe your
respect,
Sixth Amendment rights in that regard have been complied with.
I'm requesting a written judicial finding of fact and conclusion of law on this issue for the grounds that I just stated. It was seen, based on the Sixth Amendment, that I'm not being awarded the chance to face my accuser, which I should be awarded that based on the
You
Sixth Amendment.
are.
If I'm not able to face my accuser, then how can the claim even stand? How can a claim be brought against my client if I'm not able to face the accuser?
So this case is a criminal case in a court of competent jurisdiction in the state of Wisconsin, Waukesha County. This case was initiated initially by the filing of a criminal complaint. Then there was a preliminary hearing where probable cause was found. After that point, there was an information that was filed. And at some point, an amended complaint, perhaps even a second amended complaint, was filed as well, putting you on notice of the charges and the factual basis for those charges, along with the statutes that are alleged to have been violated. I'm not going to explain any further why you can't call the state of Wisconsin in the way that you've subpoenaed them or attempted to subpoena them for the reasons I've already stated. I understand where you might disagree with the court's ruling, but my ruling stands, and I'm not requiring the plaintiff in this case to serve that subpoena in any way for the defects I've already noted.
May I state for the record?
And I'm
Your Honor,
also, hold on, I'm also not going to issue a written decision on that. The record speaks for itself.
may I state for the record, Your Honor, that I have not even seen a complaint in this matter, and the jurisdiction still has yet to be proven, which is another thing that needs to be.
Shut again with the fucking jurisdiction. Kit, an information in criminal law is basically the similar to a complaint, effectively. I honestly have to look it up again because it's been so long to trying to glean the distinction between it. Information is okay. So basically, if you waive a grand jury indictment, you're instead given what's called an information instead. It basically aligning what the charges are. Basically, has the pertinent details of what's being charged against you.
Challenge. There has not been proven that there's subject matter jurisdiction as of yet. There's no verified proof of it. There's no verified proof of even a claim, especially if I'm not allowed to face my accuser. And I don't understand how you can make that judicial decision, Your Honor, when it's clear discrepancies in the paperwork of this matter. Like I said, I have yet to see jurisdiction be proven. It has not been proven. I have yet to see a complaint. I have not seen that.
The court has provided you with, I believe it was the second amended criminal complaint, along with the information that was provided to you previously and noted on the record. I've already addressed your motion to dismiss previously. I'm not going to revisit that. There's no legal basis requiring me to do that, sir. The plaintiff in this matter has presented witnesses to establish venue. And again, as I've noted previously, it's a criminal case with criminal charges, with a second amended criminal complaint detailing the factual basis upon which these charges are based. We're a notice pleading state. And along with the information, you've been made aware of all of the charges and the penalties you face and the factual basis upon which the state has brought these charges. We are in the middle of trial. Your objections are noted. We will continue today with the jury trial.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter, Your Honor?
No.
Your request is noted for the record. I'm not an appellate court, sir.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Shut the fuck up. No. He cannot. An interlocutory appeal, the short end, is basically you're making an appeal, a direct appeal to the appellate division while a case is still ongoing. That, in other words, it hasn't been adjudicated on the merits. But number one, it's whoever granting an interlocutory appeal is up to the appellate division, so he has to do that himself. Two, you can't do it in a criminal case. It's only in civil cases. You can't simply stop a trial before it's even been adjudicated to hear for the appellate division to hear it. That's not how that works. Interlocutory appeals are only available in civil cases.
Your request is denied.
Based on what law or fact, Your Honor?
I've previously addressed the issue, sir,
So
based
you're
on
making-
law of the case.
Are you making a judicial determination that I'm not awarded my Sixth Amendment right to face my accuser?
I'm not making any such determination here today. All right.
What law or
I'm
fact?
going to turn to the district attorney's office. Do you have a witness available?
Yes, we're ready to proceed, Your Honor.
All right, our jurors here. All right, the jurors will be brought out, sir.
Your Honor, with all due respect for the record, you're avoiding my questions.
Mr. Brooks, I've addressed the issues that need to be addressed this morning. I've also addressed the same issues probably every day we've been in court. I know you may be dissatisfied with the response that I'm providing to you, but my responses stand.
It's not a dissatisfaction, Your Honor. It's a lack of understanding, which I don't have. I don't even understand the true nature and cause of the charges.
Bullshit.
And
Mr.
without,
Brooks, you've been made aware of them multiple times.
I do not understand them, is what I'm saying.
Encourage you once again, if you don't understand anything, to seek the advice of an attorney. I cannot give you legal advice.
I'm not asking for that, Your Honor. I'm merely asking why are my constitutional rights being prejudiced? It states under the Sixth Amendment that I have the
Sir, I've
right.
already addressed this, okay? We're not gonna have any further argument on this topic. All right, your Sixth Amendment rights are being honored no differently than any other defendant that has appeared in my court.
Have any other defendant not been awarded the opportunity to face their accuser?
You are facing your accuser, sir. Every single witness who's been on this stand, you have cross-examined.
None of those witnesses are making a claim. None of those witnesses are the plaintiff. None of those witnesses are identified as the injured party. An injured party has to make the
Oh
claim.
my God. None of them are identified as an inter-party. Motherfucker, most of them were hit by you. Most of them had loved ones who were hit, who were injured by you, by your actions. Alleged actions, dude. Oh, God.
Sir, it's my opinion that your belief as it relates to that is mistaken. It's not a lawful argument, and it's frivolous. I've directed your attention once again to the Beneby decision.
Is that not a federal case, a United States?
You're asking me for legal advice. I'm not going to provide that to you, sir.
I'm just asking what kind of case it was. Was it federal Supreme
Yes,
Court
it's a
case?
Seventh Circuit Court of Appeals case. We're in the Seventh Circuit, sir.
But you just stated that you're not a court of appeals. But you're citing a court of appeals case.
Oh my fucking God. This guy is such a fucking
Appeals
moron.
case law applies to this court, sir. I'm bound by legal precedent from the various courts that are above me.
And you're still not explaining how I'm not able to face my accuser, which is my Sixth Amendment constitutional right.
Sir, I can't explain the law to you. I've made my decision. It stands.
I'm not arguing that part of it, Your Honor. I'm just merely
Do it to
stating
judge
for the record.
Yeah, I heard the door.
Okay, thank you.
I'm merely stating for the record that I should be awarded my Sixth Amendment right to face my
Your
accuser.
objection is noted, sir, once again. We'll continue this morning. Thank you.
None of the witnesses
And he's still going
that
as the jury is
testify
walking
are the
in.
accuser. None of the witnesses that testify are the injured party, which a claim has to be made by a living, breathing human being.
Sir, I
which
think you're
have not.
confusing civil law with criminal law. That's what
No,
I'm
I'm
saying. on that.
confusing. I'm not confusing any law. The Constitution says that I have the right to face my accuser, and under the Sixth Amendment, I'm not being awarded that constitutional right. I think that definitely needs to be on record, and that definitely is an issue that needs
Your
to be
objection is
raised.
noted, sir. If you believe I've erred in that regard, you can raise that issue on appeal if you are convicted.
May I put Your Honor on notice that I intend to appeal that decision?
No decision's been made. No decision's been made yet. You haven't been found guilty yet.
Is that a judicial determination I will not be able to face my accuser, Your Honor?
I have not made any such determination, sir.
Will you be making a judicial determination?
Sir, I have not made any kind of determination that your Sixth Amendment rights have been violated. On the contrary, I believe this court has honored those rights.
Even with me not being able to face my accuser, which is the state of
Your
Wisconsin, the
position
plaintiff.
is noted, sir.
Is
It's
that a
noted for the
judicial?
record. I've already addressed it.
Is that a judicial determination?
Sir, the record speaks for itself.
Is that a judicial determination?
All right, I believe the jurors are coming out. All rise, please.
Are you going to answer that, Your Honor, or is
No.
that a tacit agreement?
I'm not going to answer that further. I've answered it multiple times.
Is it a tacit agreement?
He means tacit, but he pronounces it tackit. Tacit.
It is not.
Then I should be awarded my Sixth Amendment right to face my accuser, or a judicial determination should be made.
Record to reflect that the jurors are coming in for the morning. Good morning, ladies and gentlemen.
The record should also reflect that I received no answer to that question.
And good morning to the remaining jurors who are filing in. Of course, we stand for you, so when you come in, you can have a seat. And thank you, everyone. Please be seated.
So that's what I wanted to show you guys before.
During cross-examination, you would had testified.
Freaking Pope, thank you for the $5. What's the significance of judicial determination? Effectively, it means that he's trying to make it seem like this is a judicial. She's placing a determination on the record. It's the equivalent of the judge sustaining or overruling an objection. He's trying to see if he can catch her and saying, "Oh, I'm making a judicial determination that your rights are being violated." He's trying to make it seem like that's going to be something he's going to put on appeal, or that he's going to have some gotcha that he can place on appeal. And she's not biting. But we're going to listen to this. At least this is a little bit of levity, though, everybody. And then I'm going to stop here because I didn't want to have this go on for long, but I wanted to keep it short and sweet because the morning back and forth that between the judge and Brooks got me really heated. But listen to this.
During cross-examination, you had testified that you did not see any brake lights. Is that correct?
That's correct.
Objection.
Ground.
Relevancy.
Overruled.
Sorry, correct, yes.
Lights. Is that? Sir, at cross-examination, you had testified that you did not see any brake lights. Is that correct?
That's correct.
Objection.
Ground.
The judge asked for the grounds.
Relevancy.
Overruled.
Sorry, correct, yes.
Okay. You testified further on cross-examination that you observed the red SUV strike an individual to your left. Is that correct?
Objection. He also stated that he was.
Oh yeah, so she got him in that little bit with her own ground. So I thought that was pretty good. I don't think he understood that he was trolled, but I'm sorry. I wanted to make this short and sweet, but I gotta go, guys. Thank you for checking in. Again, I'll be back on live at around 5 o'clock, just after 5 o'clock Eastern, again to catch the tail end of the trial. But thank you guys again. I'm sorry, and thank you for the $5. I'll see you later. Bye bye.